Thanks very much. Hello, everyone, and welcome to today's webinar on safeguarding in sport, considering subject access requests. My name's Alex Milner-Smith. I'm the co-head of the data and privacy team at Lewis Silkin. I'm joined by my senior associate colleague, Sean Nealing. Just want to say thanks very much to Sport Resolutions for inviting us to speak on this topic. And we're looking forward to speaking to everyone. Just as I'm sure everyone knows by now, this session is being recorded, and equally there's a Q&A function at the bottom of the Zoom panel. Please do ask questions all the way through. If you see me looking across, it's because I've got so many screens, too many screens, some people say, and I'll be checking on that Q&A panel, and we'll try to answer as many of them as we can. Please do ask questions whenever you like. We'll either take them as they come in, or if we're going to talk about a particular issue later on in the presentation, we'll probably save the questions when it's most relevant. So next slide, please, Sean. What are we going to talk about today? Obviously, we're going to consider data sharing in safeguarding case management context in relation to SARs. That's what it's all about. We are very conscious that there's a lot of people attending today's webinar, and there'll be varying levels of knowledge about what on earth a subject access request is. Equally, there'll be many people who are probably very sophisticated and who've dealt with many subject access requests, but we are going to start with an introduction to SARs, some technicalities around the legislation, and then we're going to get into issues that you need to consider in relation to dealing with safeguarding data, how and when safeguarding data can be shared, and we're going to talk about certain preemptive things that you can do, like putting in place policies and protocols. And all the way through, we'll try to give real life examples, probably not just in the safeguarding context, just slightly more holistically than that, so that you can bring, shall we say, slightly technical and dry legislation of GDPR and subject access requests to life. So just as the first slide, which is the next slide, Sean, we do need to give you some a short grammar lesson. We always do this with all our data and privacy sessions that we do, but there are certain, there has been a first question, will there be any handouts or notes sent after the seminar? Certainly, we're perfectly willing to send out these slides, of course, and if there are any, if there's a theme to any questions, we'll probably do a short FAQ as well. Hopefully that answers that question. So always when we give data and privacy seminars, we have to just explain some of the, in inverted commas, the grammar. Otherwise, not everything that we talk about later on will make sense. And the first key thing to understand in relation to subject access requests, and one might say in relation to data and privacy generally, is what on earth is personal data? And frankly, we've extracted some of the relevant sections from the Article 4 definition of personal data there on the slide, but I'll just give you a few examples of what personal data could be. It can be as basic and as simple as my name, Alexander Milner-Smith, or it can be as non-obvious as potentially, as per European Court of Justice legislation, a dynamic IP address that I might use for the sole purposes of shielding who I am and my identity on the internet. You might say that's a bit strange, but that is what the Court of Justice in the German case of Germany versus Bayer concluded, that a dynamic IP address is even capable in certain circumstances of being personal data. So when you look at the two ends of that spectrum, very obviously Alexander Milner-Smith versus a dynamic IP address that theoretically, I think to most lay people, would potentially seem as more likely to be not personal data. You can see there's an enormous range of things that could be personal data, from comments about me by Sean, my co-presenter. I'm sure he has made many private comments about me in Teams to others. That can be my personal data. And by the way, that can equally be the personal data of the opinion giver, Sean. So if we put that in the middle, dynamic IP addresses on the left and Alexander Milner-Smith on the right, you can imagine there is a lot of data that might be personal data. And obviously in the context of child safeguarding data, there is a lot of personal data there, from basic vanilla stuff, names of children involved, to names of yes, sorry, I'm actually having a terrible problem with my microphone, so I will lean as close as I can. Forgive me for looking so strange then on the camera. but with child safeguarding data, there is an enormous amount of personal data that is within the context of child safeguarding. Plus, there's not just data around the child, there's data around those who are involved in any investigation, those who may be accused of doing anything in relation to the child and so on. And that is all very likely to be classified as personal data. So moving on to the next slide, the next key definition that one needs to understand is data controller. Because it is only the data controller that has to respond to subject access requests, which Sean is going to talk about in a second. So again, we have extracted the definition of data controller from Article 4 on the slide, and indeed its counterparty data processor. But I'm going to give you just a couple of examples. One very relevant to investigations, and another I'll start with a couple of examples which are just a bit more holistic so you can understand. So data controller in a workplace context, I'll give a payroll example. You might be a company that engages a third-party payroll company to pay your employees and workers and so on. In that case, you as the employer would definitely be the data controller, in that you alone, or jointly of course, but alone in that case, determine the purpose and means of processing of personal data to pay your employees. You know that you have to collect their names, their bank details, their tax code, the salary they're going to be paid. And you know that you have to collect all of that, and you know the reasons as to why you have to collect that, because you have to pay them. You then instruct a third-party payroll provider, and they also have to process all of that personal data to affect the payroll, but they have no control at all over determining the purposes or means of the processing. So they are a data processor, you are the data controller. So if one of your employees were to file probably what would be the easiest subject access request to deal with ever, and they're not like this at all, but just file a subject access request relating to payroll data about me for the past 5 years, they would only be able to file that against you, the data controller, not the third-party payroll company. Now, in the context of lots of SARs that we have discussed with sports resolutions and various of our sports clients, we often deal with issues in relation to investigations. And there can be a grey area about what roles people have within the context of an investigation. You can have someone who is a controller, you might have joint controllers, you might have some processes potentially, but it is very likely that if you are participating in an investigation, which of course may involve child safeguarding data, it is very likely that in your role as investigator, and you'll probably class yourself as an independent investigator, or at least an arm's length investigator, it is very likely that you might be a data controller yourself. It's not always the case, but it's very likely that you would be. And therefore, you probably will have to respond to subject access requests yourself. There are lots of other compliance things that you have to do. For instance, you might need your own privacy notice. You might need to have your own Article 30 record, but we're not talking about those kind of things today. We're only talking about controllership in the context of subject access requests. So, personal data, data controller, actually very complex things to understand, but I've tried to explain them in simplistic terms so that everyone can understand when we talk about personal data and data controller later what we mean. And just one final point from me on the next slide, Sean, before we come on to Sean, who's going to talk about more what is a SAR. We're going to come on to this all the way through, but I thought we'd just have one initial slide just to highlight initially at a high level the kind of issues that we're going to talk about later. There will be lots of data being shared in a safeguarding investigation, safeguarding case management context. There may be data being shared with the police, with regulators, with you as the investigator, with you as a witness, and so on. And you should always be considering the relationship of controller or processor. It is very important when you share data outside even the SAR context, you understand why, what, and how data is being shared. We often see this in investigations that people forget. Okay, well, we're bringing in an expert to do an analysis of X, Y, and Z. They are going to be seeing data sets A, B, C, and D. They completely forget that is data sharing. Maybe that expert themselves is a controller, maybe they're a joint controller, maybe they're a processor. Within the third bullet point there, have there been proper data processing, data sharing agreements put in place so that all parties are contractually obliged to treat data appropriately. Equally, the second bullet point, think about data subjects who are involved in investigations. Have they been told what they need to be told about any processing that each party is going to be doing? Again, not something that we're going to focus on at all about today, but I just always think it would be remiss of us not to mention this, at least at a high level, so you have it in your mind. I'll hand over to Sean, who's going to talk about a little bit more about what is a SAR and what are the key concepts you need to be aware of.
Great, thank you very much, Alex. So a subject access request, a SAR, the intention is that data subjects have the right to see how the data is being processed. And the way that they can exercise that right is by submitting a subject access request, which requires a data controller to provide them with access to their personal data. And the right is for them to access any and all personal data that a controller processes about them. So it's potentially a very, very onerous obligation on data controllers. It also allows the data subject the right to access other supplementary information, that is information about how the data is being processed, which we'll come on to shortly. Now, you've got to be aware that a data subject access request is not just something that's received with the headline data subject access request, and it doesn't have to refer to Article 15 or even the words personal data or subject access request. A subject access request can be received through any medium. It can be received verbally. The Information Commissioner's Office, the UK data regulator, otherwise known as the ICO guidance states that data subject access requests can be received through social media channels, through emails, through letters, any form. So staff working at data controllers do really need to be aware of how to recognize a SAR. It's not just, please provide me with all copies of my personal data that you're processing, as is my right under Article 15 of the GDPR. It's, can you send me a copy of this document? Can you send me a copy of this data? Can I see X, Y, or Z? We need to consider what the data subject is intending and how to respond in certain situations. It's good practice to have a policy for recording details of the requests that we receive, particularly those made by telephone or in person, because when we receive a request, we've got certain time periods with which to respond to a request, which we'll come on to, but in short, it's 1 month to respond to a request, unless it's manifestly complex, in which case we've got 3 months to respond. So when do we tend to receive SARs? I mean, the intention I mentioned is that data subjects have a right to access the data so that they can make sure that data controllers are processing their data in line with the GDPR or with other regulations. However, it's very, very rare that a data subject will submit a request purely because they have an interest in how their data is being processed. Normally there's a background context and they're routinely used in disputes. They can be a form of pre-litigation disclosure, or it can be an attempt to try and get a controller to put a controller to so much effort that they will try and resolve the dispute in another way. They are a potentially significant burden for a controller, and as I've mentioned, lots of controllers will be processing huge amounts of data about a data subject. We think about employment context, for example. I've been employed by Lewis Silkin for coming up to 8 years. There will be thousands and thousands of emails and documents with my name on. If I were to hold Lewis Silkin to their obligation to provide me with all of the data that they're processing about me, that would take an inordinate amount of time and resource to respond to. So we'll come on to the ways in which we can reduce that obligation later on. But as I said, they're commonly used as a tactical weapon to obtain early disclosure or gain leverage in settlement negotiations. There has been case law in the case of Dawson Damer and Taylor Wessing, where the judge specifically said that the motive of the requester is not a reason for refusing. When we receive a data subject access request, we need to be motive blind. There's a couple of very rare exceptions to that. For example, if somebody were to say, I'm submitting this data subject access request, but I withdraw it if you pay me £1,000. The ICO have recognised that that's clearly unreasonable and you would not need to respond in that case. But generally, the way that data subject access requests are drafted, they are significantly broad and significantly less blackmaily than the example that I've just described, so we would need to respond. And getting it wrong can result in legal action. So, for example, if we refuse to respond to a DSAR, the data subject can sue us, or if we respond to a DSAR giving too much data and we accidentally disclose third-party data when we shouldn't have, that third party could sue us for a breach of GDPR. And it can also result in regulatory action. So, and this is the much cheaper way to put pressure on data controllers. A data subject could write to the ICO and say, I've submitted a data subject access request, but the data controller has not complied as they should have. And in which case the ICO will normally get in touch and there'll be some toing and froing, which if we can avoid, that would be preferable. So what is a SAR? So Alex has set out the distinguishing features between controllers and processors. Controllers decide how the data is processed. The processor just follows the controller's instructions. So it's controllers who are bound by Article 15 and who need to provide data to data subjects. As I've said, Article 15 affords data subjects the right of access to personal data being processed. So data subjects are entitled to a copy of all of the data that the data controller is processing about them. And as Alex said, the personal data is not just somebody's name, it's any data from which that person can be identified. So if there was an email saying, I listened to the senior associate who gave the talk on data subject access requests on the 14th of October, that would be my personal data, because although it's not my name, I could be identified from it. So you do need to think about the broad definition of personal data and what we need to provide. Not only do we need to provide access, but we need to provide further information about the data. So it's the purposes of processing. Why do we have that data? The categories of personal data that are being processed. The recipients or categories of recipient, in particular third countries where data is disclosed, and where data is disclosed to certain third countries, the lawful transfer mechanism by which that data is disclosed, the time period for which that personal data is stored, the existence of the right to request from the controller rectification or erasure of personal data, or restriction of processing of personal data if we're relying on certain basis for processing that data. The right to lodge a complaint with the ICO, the UK Supervisory Authority. Where personal data isn't collected from the data subject, the source of that data. For example, if we've got data from other third parties and not from the data subject themselves. The existence of automated decision-making. Generally, the answer to that question is we do not use automated decision-making to make decisions about you, but we would need to confirm that. And as I said, the lawful transfer mechanism for sending data to non-EU countries. Now, most of this information should be in our privacy policy because Articles 13 and 14 of the GDPR set out that we need to be transparent with data subjects and provide them with data about how their personal data, provide them information about how their personal data is being processed. So our privacy policy should cover all of this information, and many data controllers would simply provide a data subject with access to their or copies of their personal data and then say, for the information to which you're entitled, see our privacy policy or our privacy notice. Now, obviously, the caveat to that is the privacy notice needs to contain the information that Article 15 sets out a data subject is entitled to. So if your privacy policy doesn't cover that information, it's probably worth reviewing and tweaking it just so that if data subject access requests do come in, we're in a better position to respond to those in the future. But the right of subject access is a fundamental right guaranteed by Article 8 of the EU Charter. So it's very important that we do take these requests seriously. So there are additional relevant rules in the GDPR to the processing of, to responding to data subject access requests. We've got to be transparent, we've got to be clear in our communication, and we've got to allow the data subject to exercise their rights. So when we respond to a data subject, there's a duty on the data controller to use concise, transparent, intelligible language, provide the data in an easily accessible form, and just make sure that our communications are generally understood. We shouldn't be bamboozling them with technical references. We should be transparent about the approach that we're taking in responding to their SAR. We should be communicative with them. We should let them know we've received the request and how we're handling the request, and when they can expect to hear from us. Essentially, when we're responding to a data subject access request, we've got to have one eye on the data subject and our obligations to them, but we've also got to have one eye on the ICO, because if a data subject complains to the ICO will inevitably request a copy of the communications that have been sent between us and the data subject. And if we're coming across as trying to put barriers up, trying to delay matters, that's not going to be helpful. We just had a question. If a subject submits a DSAR and they are referenced in a communication or document, are the names of the sender and the recipient of the communication considered third-party information, even if they are parties related to or employed by the controller? So yeah, somebody else's name would be third-party data, but we're going to come on to the approach that we should be taking when it comes to third-party data, because there's a huge spectrum. We can redact everything, redact all third-party data to the extent that it's not mixed data, mixed in with data subject to which somebody's entitled, or we can be very transparent, and it really depends on the context of the subject access request. It depends on the context of the communications. It depends on how transparent we want to be. I generally prefer to lean towards transparency. And I've had another question. What happens if the sender of the information about the data subject sends it confidentiality? Can the controller refuse to give it? Again, we're going to come on to third-party data later, but a data controller will have duties of confidence over certain people, for example, their own employees. And if correspondence is marked confidential, then that is something that we would consider, but it is not a blanket rule that if it says confidential, we are not to disclose it. In a similar way, if something is marked privileged, it doesn't necessarily mean it's privileged. We've got to consider the document in the context of the SAR, in the context of the circumstances in which it was sent. And if we do owe a duty of confidentiality to third parties, then we can redact or withhold as necessary. But if not, and it's reasonable to disclose, then we may need to disclose that, but we'll discuss that in more detail later. So the controller shall not refuse to act on a SAR unless the controller demonstrates that it is not in a position to identify the data subject. Now, generally, we know who is submitting a request because it's in the context of a dispute and we are already in communication with the data subject, but we may need to ask for proof of identity, for example, a copy of a passport or a driving license. And the controller shall provide the requester with information on action taken on a SAR without undue delay and any event within 1 month. So the period may be extended by 2 further months where necessary, taking into account the complexity and the number of the requests. And we're going to talk later about complex requests, but generally, where somebody has requested all of their personal data, we can tend to argue that that request is complex if we have huge volumes of information about them which would need to be sifted through, and if there's lots of media that will need to be taken into account. But as in the example that Alex gave earlier, if somebody had just says, can I have my payroll information for the last couple of months? Then that would not be a complex request, and we would be, if we try to extend that, I expect there would be some pushback. It's now Alex's turn. I'll go to his slide, and there's also a couple of questions that have come up which Alex has said he will deal with.
Yes, I will. Thank you, Sean. Yeah, next slide for me. Thanks, Sean. Yes, so there have been a couple of questions. So I will deal with them now. The couple that Sean dealt with in summary, we will come to in some more detail, because obviously how one deals with third-party data is a very tricky issue and is absolutely crucial though when dealing with SARs. So we will come back to that in about 5 minutes. I think so, coming up on my slides. Just I'm not quite sure. I will cover them now. First question, someone has recently made a complaint, isn't happy with the response. I assume a complaint about something you've done, and has now said they want a copy of all paperwork interviews. We're expecting them to submit a SAR, but are you saying this one, even though it isn't, this is one, even though it isn't called one? It's a question that comes up a lot, and there's a tactical element to it. I would obviously always prefer to treat requests not as SARs, because as Sean quite clearly explained, treating something as a SAR brings with it many, many obligations. Most notably, obviously, you are suddenly within the under Article 15, and you have to comply with Article 12 and so on, and it allows someone to complain to the ICO, bring a case at court in relation to failure to comply with GDPR, UK GDPR, and so on. But there will be cases, I think if someone said to you something like, and this may not be the case here, but I'll just give some general answers so that everyone can get benefit from the question. If someone said something like, I'm unhappy with how you've dealt with my complaint in relation to whatever, I want you to give me all data you have on me. Even though they haven't explicitly said that's a SAR, I think it would be quite sharp and quite punchy not to regard that as a SAR. If someone just says, I'd like you to send me invoices in relation to me, I wouldn't be treating that as a SAR. Now, I appreciate some of you might find that distinction, those two examples a little bit fatuous because they're both so obvious, but it's very similar to the personal data spectrum. There's a spectrum, and you need to make a call as to what you're going to do, and there'll be risk either way. There'll be a risk of treating something that isn't a SAR as a SAR, in that the requester might never have even heard of what a SAR is, and suddenly you're giving them a toolkit to annoy you and cause problems, but all they really wanted was the copy of their invoices. Equally, someone might just be using loose language, and they are expecting you to treat it as a SAR, and it might be considered by the ICO so obvious that it was a SAR, you should have, as a good data controller, treated it as a SAR. So the answer to that, I hope that answers that question. It's not an absolute black and white answer, but I would say, depending on how they framed their request for all paperwork and interviews, I would say you could probably go either way. I might be more minded to treat that as a SAR, presumably because this is a complaint about some kind of investigation that's happened. As I said, there'll invariably, be it safeguarding or not, a huge amount of personal data in the paperwork and the interviews. And I presume, I suspect they do have SAR in mind. So you'd have to be, as I say, you could make a call either way, and you just need to be comfortable with the risk. And if you make a call that you feel is grey area, you should document your reasons as to why you made that call. So if they complain later, you at least have a paper trail showing why you made that decision. So I hope that answers that. Second question, as investigators and therefore potentially controllers or processors, as we think most likely controllers, is it correct that we as individuals need to be registered with the ICO? Very likely, yes, but there are exemptions and exceptions as to whether you need to register with the ICO. And I would recommend that if anyone else has that question, you go to the ICO registration page, and Sean will correct me because I rarely do these kind of things myself, but there is a page there that will guide you through. It will say, are you X, are you Y, do you do this, do you do that? And it will tell you if one of the quite complex exceptions applies to you. But most likely you probably would have to register as a controller, as I say, unless one of these exceptions applies to you. So I would go to the ICO website and run through their flowchart, and hopefully you should get the answer. So I hope that answers that. So I'm going to move on to probably what is the most interesting section, which is really, do we have to provide everything? And I'm going to come on to that in a second. But there's just a couple of points in relation to safeguarding that we wanted to raise. First point, and, I must say we haven't actually dealt with this, but we thought we should raise this. If you were to receive a SAR from a child, so someone under 13 or even under 16, I would say under 13, bearing in mind the GDPR levels for consent in the UK, if someone was 12 or 11 and you received a SAR from them, I would probably want to be talking to their parents to get confirmation, want to get confirmation from their parents that they actually are mature enough to understand the right that they are exercising and so on. Similarly, if you were to receive a SAR from a parent saying that they want to exercise a SAR on behalf of their child, you would want to understand how old that child was, because of course if the child was 16 or 17, it would be quite unusual then to actually answer a SAR from a parent. Of course, if the child was 5 or 6 or 7, that's a totally different issue. But the last thing you want to do is respond to, say, a parent in a safeguarding issue, when in fact the child wouldn't want you to do that, because Sean has already mentioned that providing data to a party when you shouldn't have done, not only going to be a breach of subject access request obligations, but can also be other more significant breaches as well. And second point there, obvious, we'll say it about 50 times probably through this webinar, but whatever decision you make, if you feel there's any risk to it, please do set down in writing why you've made a decision, just so if there is ever a complaint later, you're not scrabbling to come up with what your conclusions were ex post facto, as it were, but you've done it in advance. And by the way, that is a rule for all things data and privacy. We're like a bit of a broken record when we advise clients. Hopefully a useful broken record, but still a broken record, in that the reason why you do data protection impact assessments and so on is not only because you have to do it and it helps you plan what you're doing from a data and privacy perspective, but it's also good evidence to show your thinking and so on. Now, the absolute key point, we think, and we're going to come on to that now, of course, is the third point, where children's data arises in a third party SAR, consider it whether it be reasonable to disclose it. And we're going to talk about that in relation to third party data and so on. Before I just go on to the next slide, Sean, I'm just going to have a quick look at these questions just to check. I will come back. I will just answer this question just to finish it off. But so the question about whether we should treat something as a SAR, ultimately we want to know is how to deal with a SAR from a person under investigation, whilst an investigation is ongoing and disclosure may jeopardise investigation, whether it be internal or police inquiry. But we will come to that when we're talking about third-party data and so on. And police inquiry is obviously a very important point to consider as well, which we will come to. Next question though, do we have to inform everyone who discloses or is interviewed as part of case management process that the information they give could be subject to SAR? And if so, how could this be done without limiting the information they provide? Well, that's a very interesting point, and a very, very difficult one. I mean, you as a data controller, if you are a data controller, as an investigator, will no doubt at the start of any interview or any process will give a blurb to who you're interviewing, explaining who you are, explaining what your role in the process is, probably providing them with a privacy notice explaining the how, what and why in terms of how you will process their personal data. And as part of that privacy notice information, you should say, please note, you have the right to file a SAR, but it should probably be implied from that others have the right to file a SAR. But I would suggest it is a good idea to explain where and how far and how widely any data that someone gives you or says or communicates in an interview, how far and widely that may be disseminated. Now, that's even outside the SAR context. You would want to say, please note, what you say will be confidential, or what you will say will only be seen by me plus parties X, Y, and Z. And at that point, you might raise, please note also, it may be that someone else involved in this process files a SAR. We will comply according to our obligations, but that will involve potentially providing your data, but might also not involve that. We will respect your third party rights and so on. So I think there is a way to explain that to data subjects to give them comfort that were they to say, I only want to give this information to you, categorically on the basis that it will remain confidential as between you and me and party A, B, and C, I don't know, your instructors from sports club or wherever, or sports governing body or so on. And then that is something that should give those interviewees comfort that if there was a SAR from a third party, that you would take that into account when complying with your obligations in relation to a SAR. And therefore, when you do the balancing test that I'm going to come on to in relation to third-party data, probably not provide that data. But that is a very difficult question. It's one when we advise our investigation teams, which Lewis Silkin has a large investigation team. It is a difficult thing because you need to be transparent about what might happen with data. But if you're too transparent and you explain, yeah, there is a chance some random third party, or indeed the person who is accused of whatever heinous issue is being investigated, might file a SAR and might see data that the interviewee communicates, that can of course make them shut up. And then they're not as open as they should be during the investigation, and then the whole investigation is not as useful. So crucial question that a number of people have touched upon: do we have to provide everything? If you are a privacy activist, I think the answer is yes. They will suggest you have to provide absolutely everything under the sun. So when Sean Illing files his SAR against Lewis Silkin in a few years, we will have to provide 10 years of data in relation to Sean Illing, which will be millions and millions of data sets. But of course, the answer is no, you don't have to provide everything. And the reason why you don't have to provide everything it comes from three different areas. So one, specific exemptions provided under broadly GDPR, but more specifically the UK Data Privacy Act 2018. I'm going to go on to them in a second. And then proportionality limits under general EU principles. They were broadly developed and are still retained law from a UK perspective, but much more interestingly, we also have very clear guidance from our regulator, the ICO, about proportionality and what are the limits of a SAR. And I think Sean's going to talk about that later. You know, do you have to turn over every stone and so on? And equally, certain UK case law is far more mature than it was in it is in Europe. We have lots of useful cases talking about what is the actual width of a data controller's duties. Equally also, don't forget this, because it is something that many clients do forget. The duty to provide copy data only applies only to data, not to documents. So I think lots of data subjects don't seem to realise this, but were my name to be in the top right-hand corner of some board minutes because I was the note taker, but then the board minutes were dealing with hugely complex and confidential and contentious subjects, but my personal data was not in the rest of that document. And all I am entitled to is a redacted version of those board minutes, which would only leave the tiny top right-hand corner saying Alex Milner-Smith attended this board meeting. And by the way, we probably wouldn't even provide that. We would regard that as so vanilla, we wouldn't provide it, but Sean's going to talk about some of that later. So just in terms of the next slide, we'll start with some of the specific exemptions that you can use. Broadly, Article 23 allows this. I won't go into technicalities there. We have put in place our exemptions via the Data Protection Act 2018. And the first exemption that I want to talk about is the hardest exemption to understand and put in practice. We'll then get to some easier ones, but it is the mixed data exemption. But I will start first with looking at personal data and working out what personal data is actually in a document, because it's very important when you are looking at a SAR and how you're going to respond, that you understand how to categorize the personal data in a document. So I'll give three easy examples. If there's my name, Alex Milner-Smith, and I'm the subject access requester, that's clearly my personal data, I probably am entitled. There's then Sean Illing, but it's not mixed with my data. You know, it's not a third party's opinion about Sean. It's not my opinion about Sean. It's just clearly Sean's third party data. And then there is what's known as mixed data, where requester's data is inextricably mixed with third party data. So that might be, and I suspect this happens a lot with the investigations that those on this webinar do, but it might be a comment from someone saying, I was at the water cooler when this happened, this person came over and they said this, I felt this, they said that, and I felt this. That is very difficult to split into one person's data and another person's data. It's probably all just mixed data. And for both mixed data and third-party data, you do need to consider whether you're going to provide it. Now, I think this goes back to one of the questions asked earlier, but third-party data is often very, very vanilla. Let's say you're doing a SAR and you know, there might be Sean sending an email to me about the data subject, just saying, oh, we're interviewing Bob or Sally tomorrow. The interview is at 9 p.m. 9 p.m. That'd be a ridiculous time. 9 a.m. You don't want to do an interview with me at 9 p.m. It'd be very odd. But the interview's at 9 a.m. Now, yes, the third-party data there is Sean's name and my name as senders, and there is the requester's data in the middle. We're interviewing Bob tomorrow at 9 a.m. You could theoretically redact the third-party data of me and of Sean. But first point, if you start taking that route for such vanilla data, I mean, in the course of our work, Sean and I have been organising a meeting. We would probably have no problem with data being disclosed to the data subject. Plus, the data subject probably knows also that we interviewed him or her at 9 a.m. the next day, on that particular day. So if you do decide to take that very aggressive third-party data redaction approach, you're going to have to do it across all the documents that you do. And we then find, you know, costs and time go up in terms of how you're responding to data subject, because you have to do that for every single type of document. And of course, you know, it might be multiple people doing the reviews and suddenly you miss one and then you're being inconsistent. So we do always counsel that where third-party data is vanilla, and you know, the vanilla, one person's vanilla is another person's strawberry. But when third-party data is vanilla, we really don't think it's worth. What do I mean by the expression vanilla? I'll come to that in a second. But we don't think it's worth you bothering to redact. What I mean by vanilla is this. If I give the example, so sorry, someone has asked a question, just to be clear what I mean by vanilla. If I give that example, Sean sending me an email saying, we are interviewing data subject tomorrow at 9 o'clock. We're going to be doing it by Teams. Is that okay? That is vanilla because there's no real confidential information being disclosed about Sean or me. It's not in the context of something contentious. I don't think neither Sean nor I would really care if that is disclosed to the data subject. Compare this though, compare two examples. Sean writes me an email after an interview where we've interviewed someone and says, God, that interviewee was a swear word. You know, Sean, we obviously never do that, but I'll make it the worst example there ever could be. Sean does not want that to be disclosed. That is not vanilla. That is where we have to consider far more the balance of third-party data subject rights versus the data subject. Much more relevantly and much more likely, though, is where an interviewee, and this does go back to the previous questioner's comment about what happens if we tell people that the data they give to us during interviews might be the subject of a SAR, that might make them shut up and not give the data that they really want to, and it might make the investigation less useful, therefore. But just imagine that there's so much mixed data and third-party data in an interview, especially with some of the topics that everyone on this call deals with. You know, terrible, sensitive information where someone says, and then this happened, and then I'm not going to go into details about what this is, but we can all imagine it. This happened, this person did this person was in the room, they were watching it, this person then told me to do this. I mean, this is all potentially third-party data of multiple different people, and that is as far from vanilla as it could be compared to the example I gave of the very boring, I could have called it boring data, if you like, vanilla boring data between Sean and me. So the exemption in Schedule 2, Part 16 of the DPA, the mixed data exemption, is very, which we've sort of set out here. Broadly, a controller does not have to disclose mixed data unless the third party has consented, I'll come back to that in a second, or it's reasonable to provide such data without consent, balancing the competing rights and interests. So very difficult. I can't really give you that much guidance on how you balance that because it will be context specific. But let's go back to that question that someone asked. If you have told someone this interview will be confidential and will only be seen by sports governing body and 2 other people in the organization who are doing the interviews, and then a data subject who's maybe the accused of some kind of heinous offence files a SAR, you decide you don't want to ask the third party for consent because you think it will upset them. That is the ICO makes clear you don't always have to actually ask people for consent. So you're then thinking, is it reasonable to provide such data without consent? But you have told the interviewee that they may, that their data, they're giving their evidence under the provisions of in the context of confidentiality. So the balance is, in my opinion, already in favour of that third party and redacting that data or not providing that data. But of course, then it might be very serious, whatever offences are alleged to have taken place from the data subject. And it's crucial they understand who is accusing them of what and what is being said. So that brings the balance more in line. Ultimately, though, I have to say that it does all depend on the context and where you have told data subjects that what they are saying in interviews, and this tends to be the most contentious, or what documents they provide you will be confidential and will only be seen by limited parties. Our view, and this is only a high-level view and it's context-specific, and you have to make your own decisions, and we'd have to look at documents to help you come to this conclusion. Our view, it tends to be in most cases the third party interests are way heavier than the data subject's interests. And ultimately, we'll see later in a case, Dr. B versus GMC, the UK courts do not want to intrude on a data controller making a decision in good faith. If you are looking at these exemptions, trying to hide data and trying to come up with ways not to provide data, and that's not going to look good. If what you're trying to do in good faith is try to balance very different competing interests and ultimately come to a conclusion that maybe you don't just redact, but you fully admit the witness statements and so on from any SAR pack, you are unlikely to be criticised, because this balancing act is not a black and white question. I mean, the clue's in the name. You're balancing competing rights and interests. It isn't a 1 + 1 = 2 thing. So that's the mixed data exemption, always available, always complex, always. Oh, just back one slide, I think. Forgive me. Then there are some slightly easier ones that probably do not apply to you all the time. The first one being legal privilege. Controllers do not have to disclose data which is covered by legal privilege. That's both legal advice privilege, where a lawyer is involved giving you advice on a particular topic, and litigation privilege, which doesn't need to involve lawyers, but where the dominant purpose of any communication is litigation. There, it's a full-on blanket prohibition. You don't have to provide that information. I will raise one terribly difficult thing. Of course, some documents contain privileged and non-privileged information, so that might require redaction of the bottom, giving them the top. But in most cases, documents are fully privileged or not. There's then lawyers' confidentiality. Legal advisors do not have to disclose information which they hold under a duty of confidentiality to their client. It's a sort of an extension and a widening of the legal privilege exemption in some ways. And this may not apply to anyone on the call, but obviously if you are advising a client and there's documentation there, you do not have to comply with the SAR broadly, although this is slightly untested and we're seeing some quite interesting analyses of that from certain data subjects, with challenging that. Sean, yeah, sorry, yes. Confidential references. Employers don't have to provide data subjects, references that have been given or received in confidence. That may be relevant to what people do on the call. It obviously comes up a lot in the workplace SARs. Let's go back to the last slide, Sean, on legal privilege, because someone's asked a question. What about in-house legal counsel? Well, that is a very difficult question, slightly beyond my expertise. We tend to bring in our disputes resolution team there when we talk about what is the width of legal privilege. That all depends, I guess, according to the case of Three Rivers, in terms of what hat you're wearing as in-house counsel. Because everything that in-house counsel touches suddenly doesn't become privileged. Sometimes in-house counsel is doing something with their, I always talk about a business hat as opposed to a lawyer's hat. But in the UK, certainly, in-house counsel can certainly provide advice that can be covered by legal advice privilege. It's not like in Europe, and forgive me again, I don't want to misspeak, I don't know every jurisdiction in Europe, but often in certain jurisdictions in Europe, they don't recognise in-house counsel privilege at all. So really, in answer to that question, legal advice privilege can certainly apply to advice given by in-house counsel. It all depends on what their role is. If they're actually participating in an interview process as an interviewer, they're not being a lawyer there. I mean, they're obviously a lawyer, but they're not providing legal advice. So suddenly to start saying because a lawyer was there, it's all privileged, unless you've set it up that way somehow, I'm always very reticent about that, and people give me answers that I sometimes think don't make sense and about how they're protecting investigations with privilege. But most of the time, as an in-house counsel, if you're advising the business, that might be protected by legal advice privilege. So there's no general prohibition on in-house counsel. So let me just a couple more questions on this point. So someone said, difficult if you do not know if litigation is the real purpose of a SAR. Surely best to comply and wait, as a follow-up might narrow the scope of the SAR and reveal the risks with providing the data. Ultimately difficult to restrict unless you use legal privilege or potential legal action. So I think in relation to that question, I'm talking about the documentation that might be responsive to SAR. So as an example, if Sean was the data subject and I had been giving advice to a client, Sean's the employer, and there'd be lots of personal data of Sean in the advice I'd given, and it would potentially then appear responsive. You just wouldn't have to provide that as it was because it was legally privileged. I don't really care about the actual purpose of Sean's SAR. although Sean's SAR, of course, might have litigation as its purpose. Yes, they might be looking for pre-action disclosure and so on. But the way we look at privilege is look at the documents that might be responsive. Are they covered by privilege at our end from a controller perspective, litigation or legal advice privilege, and make that call. Another one, are internal communications easy, such emails discussing a case exempt? Is that in-house counsel? I mean, an internal communication can be exempt. Two examples. In-house counsel might be involved giving advice. So Sean might be in-house counsel, and I might have written to Sean saying, hey, Sean, can you give me advice on this investigation? It's all going wrong. I need this advice. Sean then writes back to me saying, yes, the data subject Y is saying this because he's threatening a discrimination claim. That is very likely to be legally privileged, a legal advice privilege, and you wouldn't provide that. Equally, litigation privilege, it is a slightly harder thing to understand. But if Sean had written to me and he was an investigator and he said, oh, I'm very concerned actually about something someone said, and had wrote to me and I wasn't a lawyer, but said, I'm very concerned about something someone said in an investigation. They've said they're going to sue us. I feel I need to write a witness statement of what happened at the investigation because I think they're going to claim that I bullied them at the investigation. And then Sean wrote a witness statement. I think that would be very likely that the dominant purpose of Sean providing that document was litigation, and therefore it probably would be litigation privileged, not litigation privileged. So honestly, there could be a seminar just on this, but we'll have to just move on, just bearing in mind time. So let's move on to the next slide, Sean, starting with confidential references. So talks about confidential references. You don't have to provide management information. Sometimes information relates to management forecasting, and it is exempt from the right of access if complying with the SAR would likely prejudice the business activity of an organisation. So if someone was planning a big redundancy and someone filed a SAR in relation and during that redundancy process, if you believe that providing it to that person would prejudice the business activity of that organisation, you might say the management information exemption applies. Equally, settlement negotiations, data subjects are not entitled to personal data, which consists of a record of an employee's intentions in relation to settlement discussions. Note also, there are also various exemptions in relation to criminal law enforcement. I have to say, and taxation, discharge of functions to protect the public, regulatory functions. Now, we're not going to talk too much about this because it all depends on who you are. I think there was a question earlier about there might be a police investigation ongoing. Does that mean we don't have to respond to a SAR? Well, it depends who you are. If you're the police, absolutely. If you're not the police, then I think you can still potentially use that angle not to answer a SAR. But we always tend to be quite conservative there, and we like to actually ask the police to say to us, we do not want you providing that information, just so that we have it in writing, that we're not just ourselves analysing some of the exemptions to prejudice rate criminal law enforcement actions too widely to apply to us when perhaps they shouldn't. Broadly, any time we deal with the police, and we deal with the police a lot, even if it's just the police asking for records, it's a slightly different concept, but broadly within the same continuum. We always ask the police just to confirm that they have the right to request this under GDPR. And equally, in relation to certain SARs, if there is a police investigation, I would want the police to explicitly confirm to us, unless we're absolutely certain of our position under some of these exemptions, that they do not want us to provide information to a data subject. It goes to the point that we've made a few times, and again, the broken record point. I prefer to have things in writing. I prefer, if later on a data subject complained to the ICO and said, these people were saying they couldn't provide me data because of a police investigation, I've checked the UK GDPR and it doesn't say that anywhere, they're wrong. We can actually say, well, hang on a second, the police actually told us we couldn't. So I hope that makes sense. Final point on this slide is quite important. These exemptions can seem very exciting and can seem like, great, we don't have to provide anything. But as Sean said earlier, subject access request is a fundamental right. Okay, it is a right that the ICO regards as very important. So when they look at you, if they were to look at the way you have analysed and used these exemptions, they would want you to have construed it and applied the exemption in a limited way. Rather than just looking at this great week. Yes, recording. I presume as we're recording it, yes, it will be available, and there will be slides, as we said as well. One person: to what extent could Article 15.4, to what extent could the Article 15.4 exemption, the right to obtain a copy referred to in paragraph 3 shall not adversely affect the rights and freedoms of others, be applied in safeguarding investigations, where disclosure of the data may adversely affect the ability of the data controller to conduct its safeguarding function? I think you probably could. I think you probably could look at that. 15.4 is the only point in GDPR where, and indeed I think it's in Article Recital 63, which adds colour to 15.4. We've taken those kind of things in the UK GDPR and expanded them. That whole idea of of not adversely affecting the rights of others is where the balancing test of third-party data comes from. But if you feel that it would impact a safeguarding investigation in such a way, I must say I've never pursued that line, but I can see that being arguable. And I think it's such a grey area edge case, and the consequences of providing SAR data incorrectly are so serious. You know, the falling down of a safeguarding investigation, the dissemination of data to an accused person who then might go on a vindictive campaign against their accusers. I would suggest that whatever decision you do come to, the ICO is going to look, and the courts probably would look kindly on you, and they'd understand you're in a very difficult position. So I do think the Article 15.4 exemption is an interesting one to consider. Just in relation to the next question, we do need to just move on, otherwise we're going to run out of time. But so when police ask for information under a DPA request, we should reiterate that we would want to be consulted if a SAR is submitted to them. Not quite. I don't think you could ever ask the police. You've never tied the police's hands like that. But what I would, if the police ever ask you for information, I always want the police to tell you what their lawful basis is, just so that you have that in writing. And I don't like informal requests from the police. I like them made under, good Lord, I've forgotten the section, but the proper section of the specific act that the police need that can request evidence from certain parties. So you have that there, so that you know you have to comply with this, so that if anyone later complains, you shouldn't have provided that data to the police, why did you do it? I'm not saying that you should get the police to say, and if a SAR is submitted to the police, that they must tell you, because I don't think they'd ever agree to do that. So just moving on to the next slide, Sean, which I will do very quickly. We just cut and pasted an example exemption. So this is exemption from Article 15 of the GDPR, child abuse data. This paragraph applies where a request for child abuse data is made in exercise of a power confirmed by an enactment or rule of law, and the data subject is an individual under 18. Data subject is incapable of managing his own affairs. Article 15.1.3 of the GDPR do not apply to the child abuse data. The extent of the application of that provision would not be in the best interest of the data subject. You will have more experience than I have as to when a request for child abuse data is made in exercise of a power confirmed by an enactment of the rule of law. But there's an example of where you might be able to rely on a particular exemption as quoted in the UK GDPR. I think, Sean, just for time purposes, do you want to move on to, I talked about two different streams for how you can potentially not provide data. One is exemptions within the legislation. We've talked about some of the UK DPA ones. We talked about Article 15.4. The other ones are from ICO guidance, which Sean is going to run through now.
Yeah, absolutely. Thank you, Alex. I've just seen a question come in. So
I think Sean, we'll come back to the question. Let's just move. We just get through this, because we'll try and come to the questions at the end. Sorry, Sean.
We'll get through the slides from now on and answer questions at the end. So as Alex has said, let's say my example, I've raised a DSAR against Lewis Silkin. There's 8,000 potential hits of data. There may be data which is subject to certain exemptions. So, for example, there's data which is going to be, because there's third-party data. There may be privileged data. I hope not, but there might be. There might be management forecasting data. All of that data would be covered by an exemption and therefore wouldn't need to be disclosed. However, that may still leave you with 7,800 emails to trawl through. And that's when we would rely on the fact that Alex mentioned earlier. There's only an obligation to respond to the extent that it's reasonable and proportionate. We're not expected to leave no stone unturned. So there's some really useful guidance from the ICO, which I've put on the screen here. You should be prepared to make extensive efforts to find and retrieve the requested information, but you are not required to do things that would be unreasonable or disproportionate to the importance of providing subject access. And then there's ICO comment case law. In assessing whether complying with a SAR would involve disproportionate effort, you may take into account difficulties which occur throughout the process of complying with the request. This approach accords with the concept of proportionality in EU law, on which the DPA is based. So ultimately, we are not expected to provide data subjects with every single piece of personal data about them which we are processing. And we tend to, when it comes to receiving a data subject access request from an individual, we tend to consider the context in which that request has been made. So for example, if somebody has raised a data subject access request in the context of an investigation, but they haven't mentioned that in their request, they've simply just said, I request all of my data that you're processing about me. It may be that we're processing their payroll details. It may be that we're processing performance information. It may be that we're processing unrelated grievances that have been raised in the past. It may be that we're processing, I don't know, emergency contact third-party information. There's a whole gamut of data that could be processed. But when it comes to reasonableness and proportionality, we tend to look at the reason why that request has been made. And if it is in the context of an investigation, then we would limit our searches in order that we would only be providing personal data that related to that investigation. And there are three ways in which we tend to try and limit the amount of data that we're going to be reviewing and ultimately providing to a data subject post-review. And those three ways are, we tend to look at a date range. So where I've been employed for 8 years, we would only really be looking at the last X number of months or potentially 12 months to look at the most recent data that's actually going to be of interest to me. We're going to limit by the custodian, that is the person who has sent or received emails. I'm not interested in every single employee, at Lewis Silkin, what they've said about me. It tends to be the people responsible for the investigation, or direct managers, or human resources, or head of safeguarding, or the people that will actually have been sending the material emails that relate to the context that's relating to that DSAR. And the other thing is keywords. So we're not looking for every single email that's been sent by those key individuals in that 12-month or whatever time frame. We're looking at the emails that have been sent that contain the name of the data subject and keywords such as investigation or safeguarding or grievance or witness statement, or words that will result in the most important and the most interesting data coming up, purely because we need to be able to demonstrate to the data subject and the ICO that, you know, we acknowledge that we haven't carried out a search of every single email and PDF and Word document and Excel spreadsheet and Microsoft Teams message and text message and etc that contains the data subject's personal data, because that would be manifestly excessive or manifestly unreasonable. What we have done, therefore, is rather than refuse to act on a request, which we could do if faced with a manifestly unreasonable or excessive request, rather than do that, we have been a good data citizen and carried out searches that will result in the interesting and the most key data being reviewed, and then we can review that data, still reviewing a significant chunk of data, ideally reducing it from 10,000, 8,000, whatever, to about 1,000. So you can still, in most contexts, unless it's a very specific request, about 1,000 documents, so that we can demonstrate to the ICO that we've done a good job, we've taken our obligations seriously, we've still reviewed a hefty amount of data, and we've been reasonable and proportionate. The key is demonstrating to the ICO that we have been reasonable and proportionate in undertaking our obligations. Now, I've mentioned that where we receive a manifestly unreasonable or excessive request, we can refuse to act. That is likely to be a high threshold, and it's up to the data controller to demonstrate that the request is manifestly unfounded or excessive. Now, I would say it's going to be a significant amount of data to say that it's unfounded or excessive in the tens of thousands, possibly hundreds of thousands, because as I said earlier, the right of access is a fundamental right, and controllers are expected to go to take extensive steps to uncover data. So that's why we recommend, rather than say it's manifestly unfounded or excessive, we are refusing to act on the request, we would say it's manifestly unfounded or excessive. We could refuse to act on the request, but rather than do that, we're narrowing it down. So we are still taking steps to allow data subjects to have access to their personal data. And that should reduce the risk that we are being seen as the evil data controller that is not allowing any data subject access rights. And this is an approach that we've taken for a long time now, and the ICO tend to be on board with that reasonable and proportionate approach. We're not going to deal with the tens of thousands, but we will deal with the limited request. Somebody's asked, and this is on point, if somebody is asking for all personal data and they refuse to limit their requests by date range, or provide a reason and has been a key officer of an association for years, does this refusal to clarify the purpose assist in refusal of their request as manifestly unreasonable? Now, the approach that we would take is we wouldn't tend to say to the data subject, you've asked for all of this, we're proposing a more limited search, do you agree with this? What the approach that we would tend to take is, you've asked for all of this, we are going to do this, let us know if you have any concerns with this approach, otherwise we will proceed on this basis. And then we plow on ahead and proceed. If they say, this is outrageous, I'm entitled to everything, then we would say, well, everything was 100,000 emails, and that's not reasonable and it's not proportionate to review all of that data. If they say, you've only searched for 1 year, I want to search for 10 years, I agree everything is unreasonable, I want to do a 10-year search rather than a 1-year search, and that increases the number of emails from 1,000 to 10,000, then we would probably again say that is not reasonable or proportionate, we're going to stick with 1 year. If they say, you've searched for 12 months, actually it should be a 14-month search because that 2 months was really important for the X, Y, or Z, which is why I'm raising this request, then I think in that situation, if we refuse that, we would probably be the ones to appear to be, the ICO would probably consider us to be unreasonable. So it's all about, and I hate to go back to this, but it's the range, it's the name versus the IP address, it's a third-party data balancing act. It's all about how we're going to look in the eyes of the ICO. So if a follow-up, if we've said we're going to do this and they follow up and say, well, actually, can you tweak it in this minor way? I would suggest that we do that to show winning and to show that we are being a good data controller, and we do genuinely want to be as helpful as possible in providing personal data to data subjects. Alex, I think this slide is yours.
Yeah, so just before we go on to just want to talk about quite quickly some practical tips about how to handle SARs and potentially creating a policy before I finish with some run through the case law, and Sean then talked about some of the enforcement actions. I just wanted to raise a slightly different issue. Again, we just felt we should, because it's related. How and when can safeguarding data lawfully be shared without consent? This is outside a SAR context, but this is if people are asking you for data, law enforcement agencies or other interested parties. I say interested, I don't just mean puerile interest, I mean those that have a stake in whatever investigation is happening or so on. If you are going to do that, you need to be very sure that you have a lawful basis to share the data. So just for normal data, you'd only need your Article 6 basis, legal obligation or legitimate interests. But bearing in mind safeguarding data very likely contains elements of as personal data that is known as a special category data, you will also need an extra Article 9 condition. And the question there is, what is that Article 9 condition? It's not always going to be relevant. Providing information to the police, it'll probably be substantial public interest or one of the UK Data Protection Act explanations or extrapolations of substantial public interest. There might be occasions when you need to share it because you're being sued. So it might be you need to share safeguarding data for the establishment, exercise, or defence of legal claims that you might be subject to, or if you need to take legal advice. But do be very cautious of sharing any safeguarding data. And I'm talking about this generally, not within the SAR context. There's obviously all the complexities we've talked about in relation to SARs. And that's just a sort of 1 minute point that we just wanted to make there, not just to slightly broaden this out from the SAR perspective. Indeed, it could be an hour-and-a-half seminar in and of itself. I'll come back to you, Sean, before we come back to me for the cases.
Yeah, absolutely. So this is essentially the basic steps of how to handle a DSAR or a SAR. The first thing is, as I've said, generally when we receive or a client receives a data subject access request, they know who has submitted it because there is some context bubbling underneath. But if we receive it from a strange email address or from an unrecognized phone number, then it's always a good step to ask for some ID, because what we absolutely don't want to be doing is providing a huge bundle of data to somebody who is not purporting to be who they say they are. So if we're not sure about who that individual is, always ask for ID, because we don't want to be in hot water. And then the first thing to do is to start that high level search. So I'm going to go back to my example. I've submitted a DSAR to Lewis Silkin. Lewis Silkin should then run a high level search. I've said, can I have all of my data, please? So they've searched the systems for Sean or Illing, and there's 20,000 emails. Now that is the basis by which we are going to go back and say it's manifestly unreasonable and excessive to respond on that basis, because there's just too many emails to have to review. It would be unreasonable and disproportionate to review that number. But it's important that we carry out that high level search, because we need the evidence with which to go back and push back. If we were just to say, we think this is going to be unreasonable, then the ICO will say, well, where's your evidence for this? We need to be transparent, and we need to have run that high level search to demonstrate why it's unreasonable and disproportionate. We should acknowledge the SAR and set out whether or not we think it's excessive, in which case we're going to limit the scope. Or if it's an easy SAR, I want my payroll data for the last 10 months, we will go back and say, we'll get that to you within the month. And once we've done that and said we think it's excessive, we're going to narrow down our searches. We're actually extending the deadline from 1 month to 2 months because of the complexity of the request. We would hone down the searches in those 3 ways that I set out, with the custodian, the date range, and the keywords, narrowing it down from, let's say, 20,000 to 1,000. And we would say we've carried out these searches. We've got 1,000 documents to review. We're going to get back to you within the new 3 month deadline. Let us know if you have any questions. And then, as I said, if they say, can you extend it by a month? Probably fine. Actually, I want everything. Not fine. We're going to carry on. We hone the searches and then we review. So we're going to consider the third-party risks. Alex talked about the vanilla or the boring or the anodyne data, i.e. the data, we're interviewing Bob at 3 o'clock. Can you send me a copy of Bob's terms and conditions for the HR file? Met with Bob and he seemed nice, let's hire him. Those are the kinds of things where the third party isn't really going to care whether the data center can see that email that's been sent or received by them. And so I'd recommend that we probably be as transparent as possible and provide those documents without redaction. However, the emails just had a very difficult conversation with Bob. I think he should be fired, or let's discuss ways in which to terminate Bob's contract. He's very, very difficult. Those are the third-party issues where, those are the types of emails with third-party issues where we really need to put our mind to it and decide what approach are we taking here. We'd also strip out all of the privileged information and consider to what extent litigation is in contemplation to decide whether litigation privilege applies, consider all of the exemptions and make sure that exempt data is stripped out. And then we'll draft that cover letter to accompany the data that we've decided that we're going to provide. And that cover letter will either say, here's our privacy policy that sets out all the information to which you're entitled, or it will set out that information that we covered at the very beginning, the purposes of processing, the categories of data, the recipients, the et cetera, et cetera, et cetera. And then we prepare to follow up on any complaints you have about handling. Now, however well and however many documents you review, inevitably there's going to be a significant number of complaints, because with a lot of data subjects, they just will not be happy unless every single document has been reviewed. In which case we will prepare to draft a letter with one eye on the ICO saying, we carried out a search, there are 100,000 documents, this is clearly excessive. Here's the ICO guidance that says we've got to be reasonable and proportionate. We've carried out further searches. We're still reviewing 1,000 documents. Those documents have been caught by searches which we have deliberately put in place to capture the most key documents which you're going to be most interested in, bearing in mind the context. This review of 1,000 documents took many hours, and we are providing you with these documents which have been reviewed individually because of the need to consider complicated third-party exemptions. We can't possibly, waive privilege. There's so many issues that need to be considered. So we're setting out the real effort that's being taken place to provide individuals with data. And then the ICO will most likely say, well, it looks like you've done a good job there, carry on. Occasionally you might get a case officer who is a bit more zealous than others, and there may be further searches to be carried out, but that's quite rare, unless we've been really restrictive with those initial searches and only reviewed about 50 documents, in which case I'd probably advise that you don't do that. But we need to think tactically at all times. What is the data subject trying to achieve, and can we provide data that coordinates with that motive, i.e. not just providing him with everything or her with everything, but providing them with what they need, what they want, and who is my audience for correspondence. It's both the data subject and the ICO, and as long as we're appearing to be reasonable, it's unlikely that we're going to be getting in too much trouble with the ICO. Issues to consider when creating a policy or protocol. A lot of clients say, we get a lot of DSARs, what we would like is a document that sets out how we need to respond. Now, there are some basics that we can cover. We should cover the need to record DSARs that have been received. We should cover the need to respond within 1 month, either extending or providing with access to data. We should cover the fact that we should not be looking at every single document, and we should be covering things that like the third-party exemption and privilege. But ultimately, each DSAR is very different. We can have the person that says, I want my payroll data for the last 3 months. We can have the person that says, I want the witness statement from Billy Blog. We can have the DSAR that says, I want every single piece of data that you're processing about me and I've been employed for 20 years. We can have the DSAR that says, I want a copy of someone else's contract. We do occasionally get people asking for other people's data, which obviously is not the point of a DSAR. Also, every DSAR, so it's really difficult to draft a DSAR policy that says this is how you respond to a DSAR. Ultimately, I think the main points to consider when it comes to DSARs are: bear in mind the ICO, be reasonable and proportionate, be prepared to respond swiftly, be transparent, and kind of follow those key steps. Respond as has been requested if it's reasonable and proportionate, and if it's not, put in steps to make it reasonable and proportionate. But each DSAR is going to be the reasonable and proportionate steps taken will very much depend on the facts, and we need to consider each DSAR as it comes, essentially.
Thanks, Sean. I'll talk about some cases. Now, what I would say is we're talking there about SARs in a workplace context or in an investigation context, because obviously context today. We also help many clients with what I'll call marketplace SARs. They might get 100 a day, they might get 1,000 a day. Indeed, as one of our clients received something like 3,000 on the evening of 25th of May 2018 when GDPR came in. Marketplace SARs are much better suited to strict policies and processes, because if you don't follow the same approach each time when you're receiving 100, 200, 500, 1,000 consumer SARs, marketplace SARs a day, all your business is going to do is respond to SARs. So they're much better suited to having pro forma responses, dealing with everyone in the same way. When there's ever any nuance, as there tends to be in the workplace situation or in an investigation situation, or indeed I'm probably have to disclose this. Lewis Silkin now receives SARs from opponents, and we don't really have to answer them, but we receive them all over the shop now, and they're very complex in some cases. That does not sit well, as Sean suggested, with just a pro forma response. And you might think, great, we'll just follow this protocol, but it might bite you later when the ICO potentially looks at it on the court. I'm going to run through some court cases now. I will just come back to these couple of questions, just because I feel it's the right kind of time. One is not a question. Just want to thank you for an excellent, clear presentation. I obviously didn't have to read that out, but thanks very much. First one, are you aware of whether ICO action, of any ICO action taken against an organisation as regards failure to act in relation to a safeguarding SAR? No, I'm not, but that comes back, I think it's the same question to your first question. Can a controller legitimately refuse to provide information as part of the SAR, with the reason being that it may possibly be part of an investigation? It may be that after you do some analysis, you don't provide anything because of the exemptions that you have access to. What we don't like, and this is a nice segue, and I will come to your other question as well in a second, the other part of that question. What we don't like, though, and what the ICO and what courts don't like, is guesswork. So in this first case that I'm going to just talk about here, Dawson Damer versus Taylor Wessing, Taylor Wessing obviously being a very prestigious and brilliant law firm, no criticism of them, I think they're very unlucky here actually. But in this case, I won't run through all the facts, but they broadly were found to have just assumed that all the data potentially responsive to Dawson Damer's subject access request was covered by privilege, and therefore they just said, we're not going to answer. Now, the court, the Court of Appeal actually concluded that Taylor Wessing were not entitled to rely on some of the proportionality arguments that Sean has talked about, which were not evidence-based. So they hadn't done some of the things that Sean had set out, you know, let's do some searches, my goodness, it's 100,000, tested how big it was. Equally, they hadn't tested their assumptions on proportionality and whether all documentation was covered by privilege without conducting an assessment of the data. So, that kind of comes back to your question, questioner. You know, just making assumptions, right, we're not going to deal with this SAR because it might be X, Y, and Z. That will get you in trouble. It doesn't mean your ultimate conclusion won't be every piece of data that is responsive is actually wrapped in an exemption and we don't therefore have to answer. But you need to find some way of testing so that it's actually, you feel confident that you could defend your approach to the ICO or the courts. So I would, it may be that you can refuse to comply, or not refuse to comply but not provide anything because everything is within an exemption. But you do need to test that in some ways. Equally, Dawson Damer has confirmed something that courts previously have confirmed, but we thought we'd put it here. SAR regime does not recognise a motive test. And indeed, it's in the ICO guidance as well. In the old days, pre-GDPR, you know, we'd occasionally have people saying, this is a misuse of SAR, we're not going to answer, this is pre-action disclosure, you're just trying to cause problems, we're not going to respond. The ICO is not foolish, they know when someone is doing this, but they have to regard SARs as motive blind. Going back to the fundamental right point, this is someone exercising their fundamental right, and it's very rare that a SAR is now manifestly unfounded. Sean talked about demanding money and so on. It very rarely happens. So do bear that in mind. SAR regime is motive blind. Now, there is another question here. Just can you just refuse a manifestly excessive request, or can there be an agreement as to reasonable parameters? I think Sean did talk about that earlier. It's quite gutsy just to refuse a manifestly excessive request. We tend to always prefer, okay, you want 1 million documents. We're going to still do something for you, and here's 1,000 documents. By the way, we've spent 50 hours reviewing it. We're trying to always look good for the ICO, trying to help someone, or at least engage in a dialogue with the party to reduce the scope down. Occasionally, we have been involved in where someone has said, this is totally manifestly excessive, we're not going to respond, but it's a very narrow ledge to walk down. And you know, we do prefer other ways. You've got to be pretty confident this is definitely bang on manifestly excessive. We certainly never counsel the other partner of manifest excess, where rather than refuse, you can demand a fee. The reason why we don't like that is because the ICO, the ICO, I'm very conscious of time, short time, yeah, so I'll get going. The ICO have sort of suggested that the fees you might charge would be very limited. So if you suddenly say, well, this is manifestly excessive, so we want a fee of £1,000. If someone pays it, you'll then hoist on your own petard, as it were, and you probably have to then comply. Whereas what you'd want to do is say, we'll do it, but you have to pay us £100,000. But then you're going to get in trouble because the ICO won't like you saying that it's going to cost you so much. So manifest excess is something to use as a tool to show this is manifestly excessive, but then to back off and show how reasonable you're being. Quickly through the next two cases, I won't tell you any of the background, but it's a Handouts, great case, confirms reasonable proportionate searches, not to leave every stone unturned. We love that case because there wasn't ICO guidance quite as clear at that point. There is now the new ICO guidance that Sean referenced, but it's still useful to have a Court of Appeal case saying that. Dr. B versus GMC, this is the one which I talked about where the Court of Appeal clearly says, Lord Justice says, I think, that courts should seek to review, should not second guess the controller's decision on how to strike the balance between disclosing data to the data subject and protecting third-party data. So it's not, as long as a data controller has made reasonable efforts and has not done something that's so sharp as to be ridiculous, there is a court mandate that the court is not supposed to second guess a decision that a data controller has made. Sean, you are right, 3 minutes, better rush through the last 3 slides and then I'll say goodbye.
Yeah, apologies. I've got a hard cut-off at 3:30, so I'll just whiz through these. Courts versus ICO enforcement. I've already said somebody could bring a claim to the court for breach of data protection obligations to provide access to data, but High Court action is incredibly expensive, and therefore most people will go to the ICO and say this data controller is not complied with the data subject access request. Having said, I mean, the benefit of court action is compensation. The benefit of the ICO action is pressure on the data controller, and the ICO can also take enforcement action. The problem with the ICO and with the courts actually is both take a very, very long amount of time. Where data subjects have complained to the ICO, we tend to see them following up 6 months later saying, can you try and sort it amongst yourselves? And then, maybe a couple of months later saying, we've received another complaint. It takes months and months and months. So we tend to hope that clients can resolve issues with data subjects directly in the time that takes place. And if not, hopefully the ICO would be satisfied by our reasoning in 8 months' time. Right, I've kind of already covered. Early constructive engagement with the requester is crucial, i.e. these are the searches we're carrying out. Let us know if you have any complaints. And if there's something reasonable that you suggest, we can do that. Adopt a careful, considered approach to the devising of search protocols. So those 3 custodian timeframe keyword, make sure that they are actually applicable to the background of the DSAR. Don't make untested self-serving assumptions, as Alex said. This is all privileged or this is all third-party data. Make sure that you can back that up with searches or evidence. Demonstrate a committed approach. So carry out searches, review documents, and make sure that you can demonstrate to the ICO that you have taken steps rather than just computer says no. And constructively engage with the ICO should it get to that. One hopes it doesn't, but if it does, don't be rude to them. Just set out the reasonable and proportionate steps that you have taken and justify your approach. Record keeping, as we've been saying throughout, make sure you keep a record of the requests you've received, how you've responded, the data that you've sent, so that if a complaint does arise down the line, you've got evidence to show the steps that you have taken. Questions have been asked throughout. If you've got any, do get in touch. Our contact details are there. And we've had one last question.
Yeah, Sean, I know you need to go. So I actually also got a hard 3:30. So you'll have to figure this out. We'll try to answer this very quickly. If a data controller redacts information on a non-confidential communication, let's say detrimentally references the professional character of the subject, arguably not vanilla. I'm actually being told, but redacts only the sender and not the recipient. Would that be deemed more questionable, if not unreasonable, than redacting both sender and recipient? Well, it's a balancing test. I think, bearing in mind it's the sender who made the detrimental references, I would suggest that's the person that you probably are more concerned about in terms of protecting their third-party data. So I think it would be odd to what you would have done is then made a call that the impact was going to be on the recipient, not the sender. So I would find that quite strange, but again, I haven't seen the context. I just want to say thank you to Sports Resolutions, and we are, I'm afraid, going to have to leave quite sharpish, but you've got our details there. And if you have any questions, do feel free to contact us. And as I say, we'll work with Sports Resolutions to send up a follow-up email to everyone, and really appreciate a number of people who attended, and we obviously had many staying right until the end. And so thank you very much to everyone. Cheers.
Thank you very much, everyone.